We have Mr. Lewis with us.
We do not.
All right, Ms. Spillane, have you had any contact from Mr. Lewis?
No, sir, I have not.
All right, why don't you go ahead and update me on this, and then we'll decide what to do from there.
Sure. Mr. Lewis had posted bond in the amount of $750 at the jail on June 25th. We are requesting that that bond be forfeited to this docket. This is an arrears only case with a balance of $2,052.82, which does not include that bond amount that will be forfeited if approved. And I do want to note that the only payments that we have been receiving from Mr. Lewis are from previous bond posting. His last voluntary payment was back in January of 2025.
Apparently he likes this game. All right, we'll forfeit his bond and we'll issue a new one. With 25% of his outstanding balance, and he can sit in jail and pay his bonds pay his child support that way. Find a bench warrant for his failure to appear today.
Your Honor, I'm with Devin Lewis.
Well, I can't see who you are right now, sir, so where's Mr. Lewis?
There's Mr. Lewis.
Mr. Lewis, why weren't you present when we started your case?
Left. Hello. I can hear you now.
Mr. Lewis, why weren't you here at the beginning of the case?
I was unaware that I had a court. I haven't checked my mail to see that I had a court date. I apologize.
Well, the friend of the court says you haven't been making your payments. Why not?
I have no real good reason as that what I can give you is why I'm not making my payments. I don't have no good reason. I just haven't been updated. I've been neglecting it.
So do you want to go back to jail?
I do not. I do not.
Well, the only way to stop that from happening is to make your payments.
Correct.
So what should I do with you? You just got out of jail, right?
I did.
So why haven't you learned to make your payments? Why do I have to keep putting you back in jail?
Well, so like my first time was because I paid that bond and I was thinking that it was going to go towards it, and then it never did. And then the second time it never went towards my bond either. So I've gone through this warrant situation about 3 or 4 times, almost doubling what I owed you guys. Because none of my bond went towards any of my restitution, or I'd be paid off times 2.
Ms. Spillane, can you give me an update of his last bond payments and what's been credited to his account and what his current
Because
account is?
I had a $1,200, $750, another $750. Yes.
Mr. Lewis, just listen. She's going to tell you what your status is right now, and then we can talk about it. Go ahead, Ms. Spillane.
Sure. So I think part of the confusion is that when bond is posted, we have to have these hearings to forfeit the bond, so you don't see the credit right away. But correct. I have notes here that there was bond posted in February in the amount of $700, back in January of 26 in the amount of $925, and back in May in the amount of $1,400.
Yes.
After today's bond is credited to your account, your balance will be $1,302.82.
That'll be my total.
Correct.
Okay.
So the bonds have been appropriately applied, but the problem is there's no payments between bonds. There's no it's you don't make your payments, we pick you up and throw you in jail. You pay the bond, you get out. You don't make your payments, we pick you up, you pay your bond. So you're always paying after you go to jail.
Yeah.
Why do we need to do that? Just make your regular payments.
I have no good reason, and I'm gonna come in there and I'm gonna take care of the whole remaining balance.
When are you going to do
Bi-
that?
I mean, if I can make it to the courts today, I'm currently out working right now. I don't know if I can, but I can 100% sure do it Monday.
All right, I'll give you till Monday. I'm going to adjourn this for 30 days. Make your payment Monday and
Okay.
pay the whole thing. If you pay the whole thing off, then I'll cancel the hearing for the next day. If you
Okay.
don't come in Monday, then I'll see you in 30 days, and I'm likely going to say go to jail, go
You
directly
you
to jail.
you will not see me. It will be paid Monday.
All right, that sounds good. I'll see. Make sure that happens.
Will do. Thank you.
All right, thank you, sir.
Mr. Van Horn is here for 3 different show cause, and then there's also the issue for the reimbursement for the fraudulent credit card issue.
Yep.
So I'll start with the show cause portion for this case. It was adjourned from January 26th to monitor the defendant's payments. He has since secured employment, and we do have an active income withholding order. On this specific case, it's arrears only with an ordered on arrears amount of $73 and a balance of $2,700.57. Because this is arrears only, it's lowest priority as far as getting money from that income withholding order. The money's been going to other cases first. So no money has been applied to this case yet, and the last payment for this case was back in June of 25 in the amount of $115.37.
Now that there's an income withholding order, will there be monies being paid to this account?
It would depend on how much money is being taken out of the checks. He does have the 3 cases with us, and then I do believe there's one more in another county. The charging cases will always get priority first. And if those are satisfied, then this one might get a little bit of money. It's hard to say for sure, though.
But he's done everything that he can do at this point. It just depends on what he's being paid and how many hours he gets at work. So as long as he's making every effort to be employed full time, he's doing what he can. Would that be a fair way to state it?
Correct. He does have the ordered on arrears of the $73. But I also understand that there's only so much that can be taken out of his checks.
All right. So as to this matter, let's simply adjourn it for 60 days to see how the math plays out and how he's doing on his ordered on arrears in this case and the other matters as well. And then let me hear on the other 3 cases, and then we can address the issue of the credit card or the payment, that's the reimbursement request, once I've heard all 3 cases. So let me call the next case, and then we'll hear that as well. Well, let me just do the one I've got in front of me. All right, next matter is Megan Van Horn and Sean Van Horn, file 17-16848-DM. If you could update me as to that one, please, Ms. Blaine.
Yes, sir. This one charges at $295 per month, and then there's an additional $50 ordered on arrears. The balance is $6,990.34. And the last payment received was from that income withholding, and that was in the amount of $253.03.
And is that what you anticipate receiving each month from his income withholding? Or you don't know?
Here, give me just a second to pull up what we are requesting on the income withholding. Mr. Van Horn, how often are you getting paid with your current employer? Is it weekly, biweekly? Weekly. So it is looking like it's going to try and take at least $89.08 every week.
Okay.
And that's just for this specific case. It'll be different on the other ones.
All right, but that looks like it'll cover the 295 and the 50 per month, which would be 345, and $90 times 4 would be 360. So it's very, very close to the amount that we're looking at. So that one appears to be all right. So let's do the same thing on this one. Let's adjourn 60 days just to monitor, see how the income withholding math works out. As long as he's close or right on the money, we'll just let it ride at that point, as long as that income withholding order is in place. All right, let me call the last case then. This is Nicole Garcia and Sean Van Horn, file 09-13045-DS. Ms. Spillane, update me on this one, please.
This one is collecting at $294 per month with an additional $50 ordered on arrears. His balance is $7,613.20, and the last payment was for this month in the amount of $252.18.
Looks like the income withholding order is doing the same in this case as it was in the other one.
Correct.
All right, so it looks like his monthly amounts should be covered or very close to being covered if the income withholding order continues to work correctly. Was that your assessment?
Yes, sir.
All right, Mr. Van Horn, how many hours a week are you working?
I'm working, I don't get paid hourly, I get paid by the load, a percentage of the load. So, me being a truck driver, I'm only required to work 70 hours per week per federal government guidelines. So I've been pulling in anywhere between 5 and 6 loads, and I get 25% of those loads. So basically I hustle, and I try to burn up my 70-hour work clock every week. Usually I get down to about 60 hours per week, but again, I don't get paid by the hour. I get paid by a percentage of the load.
All right. I just wanted to see that you're working basically full time, and as long as you're doing that, you know,
Yes, sir.
I think you're doing what you need to do, and I'm going to be as lenient as possible as I can with you, as long as you're making every effort to work full time. So I'm going to adjourn this matter out for 60 days on all 3 files, and let the income withholding order math do what it's going to do, and we'll see where we're at with that. So I think on that side of things, you're doing what you need to be doing. Ms. Spillane, can you update me as to that request for reimbursement and how things went with that?
Correct. So back on June 26th, we had addressed this matter, and he was instructed that he needed to repay the $550 within 30 days. And that he must also contact Chime and provide any relevant documents to friend of the court. We have not received any updated information regarding the situation since the last court date, and that he has not made that payment yet. He would need to pay the court directly, either with cash, cashier's check, or money order.
Mr. Van Horn, what's happening with that?
I've been struggling with it. I've been working a lot of hours, Your Honor. I did contact. It's been complicated. I contacted Bay County because I was supposed to contact them with where I reside. I talked to the captain there. There wasn't much he could do, so he pushed me to 911 to call them and see if they could guide me into the right direction. I did get as much information as I could, and I apologize, Your Honor. I just had to do that recently. It's been difficult with me being over the road and me driving, and having to get loads. You know, it's just been difficult, but I am working on the investigation. Your Honor, I'm going to request if we could, in order for me to make this payment, we can do a garnishment out of my check, until that gets caught up. That's something we can do.
Why can't you just take money out of what's being given to you after the income withholding order and take it to the friend of the court's office? Because,
Your Honor, I have obligations as well. I have rent. I have bills. There's, I have obligations I got to meet too. That's the reason. I wish I could, Your Honor. As I was going to say before you spoke to Ms. Terr there, I do get safety bonuses. for my performance. I am expecting one probably within the next couple of months because I do get a quarterly safety bonus, which is substantial. And I was kind of hoping maybe I could take that and maybe pay that off. But I was hoping also if I could get the court's permission to maybe have a $50 deduction taken out of my check each week until that happens. I'm doing the best I can, Your Honor. I swear to God, I'm doing the best I can.
Ms. Spillane, do you know what he's making on a weekly basis?
I'm not sure what he's making on a weekly basis, but unfortunately, we would not be able to do a garnishment for this situation as the friend of the court doesn't have a way to do that. If he's able to send in payments, that might be different, but we can't garnish.
On the income withholding order, do you not know what his financials are?
We put in the request of what we want to receive, and that's what they send in. They don't always necessarily give us information as to what his wages are. That'd be on Mr. Van Horn to supply any kind of income verification.
I can give you an estimate, Your Honor, if you would like.
No, what I'd like is actual dollar amounts that you're making. How long have you been working for this company?
For 1 month.
I'm sorry, I didn't hear that.
1 month.
So you've gotten 4 checks?
I've only gotten 2. My first paycheck was a $500 sign-on bonus, which was half of that was garnished for the support. My second paycheck was only for 27 hours, which was for my training pay of my week of orientation, being trained. That was only 27 hours, so my check was not very big. And last week, I finally got my first payout, which was also garnished, and which left me with very little to take care of my responsibilities back at home. And this week, I netted $1,100, $1,200, Your Honor, sorry, $1,200, which was also half of that, a little more than half of that was taken out as well.
All right, here's what we're going to do. I'm going to adjourn this matter for 30 days. You're going to make a payment as large as you possibly can make in that 30 days, and you're going to submit. You should have 2 full-time checks. So I want to see 3 full week checks to the friend of the court, a week in advance of that 30 days. So 3 weeks from now, you should have 2 paychecks before that 3rd week, and you already got one. So you should be able to send 3 full-time checks into the friend of the court's office a week in advance of 30 days from now. So 21 days from now. Then that way the friend of the court can have some time to calculate what they think you should be able to pay in addition to your maximum effort payment for this month. So $550, make a large payment towards that this coming month as much as you possibly can. I'll leave that up to you.
Okay.
And then we'll assess at next month's hearing how much more you're going to pay the next month and how long it's going to take you to pay that $550 off. And then I'll see you in 2 months on your regular payments through the income withholding order. Ms. Spillane, any questions about that?
No, sir.
Mr. Van Horn, any questions?
No, Your Honor, that sounds fair. I appreciate you. Thank you.
All right. Good luck to you, sir.
Thank you.
Court's going to recall the matter of David Barber and Scarlett Lick, file 15-15751. Ms. Spillane, I believe that may be Ms. Krause's case. All right. Mr. Barber, why weren't you present earlier in court at the appropriate time?
I was in the wrong meeting. I was in the magistrate meeting. I had to call the county court clerk to make sure that I had your Zoom meeting. So when I was signed in, I took a screenshot that I was signed in, but I was just signed into the wrong meeting, Your Honor.
All right. Ms. Kraus, can you update me on this matter?
Yes, this hearing was adjourned from June 17th to appear today in front of your honor to further address contempt as payments have not been made as ordered. The plaintiff has failed to submit documentation as ordered. The plaintiff monthly support obligation is $592 with an arrears balance of $4,132. The last payment that was received was in March of this year in the amount of $1,500. There was a previous hearing in front of the referee when the medical documentation was discussed that it was not provided and still has not been provided even at the most recent evidentiary hearing.
Mr. Barber, what's going on with you not making your payments and not submitting your documentation?
I have returned the documents to Pond Lee Hockey, and the documents were also submitted to the friend of the court, so I kind of object to what she is saying. I'm not sure why the documents haven't been able to produce the documents when I have turned in those documents.
How did you do that?
I'm waiting for the letter from the mail.
I don't understand what you're trying to tell me. The question was, how did you submit the documents to the friend of the court?
They were mailed in.
So do you have proof of that? How did you mail them in? Did you just use ordinary postal delivery, or did you do a certified mail? Or what did you do?
It was just a postal delivery.
So do you have a cover letter or anything that you can show that shows a date on it that says this is when I did that?
Not currently in front of me.
Well, do you have access to that such a thing?
Excuse me?
Do you have such a letter? I know you don't say you don't have it in front of you, but did you actually do a cover letter with a date on it that shows when you sent the mail to the friend of the court?
Yeah, can I have the letter fax from Pond Lee Hockey? That's my attorney that's going for my disability.
Your Honor, he did provide the disability application at the evidentiary hearing, but what he did not bring and what was indicated by the referee was the medical needs verification, which he indicated he had, but he did not bring it. And the referee had indicated multiple ways that he could submit that on the June 17th hearing.
So, Mr. Barber, did you submit that medical needs verification form to the friend of the court?
I'll take it. I'll find it right there, and I'll resubmit it personally today, Your Honor.
That's a great idea.
If that's what needs to be, I have the medical documentation in my hand and everything. So,
all right, let's get that done. When was the referee hearing, Ms. Krause?
It was on June 17th. It was a motion hearing. I believe it was in regards to parenting time, but when the case was called earlier this morning, you had indicated to contact probation about work that was reported, so maybe he can verify that information. I will still contact probation, but he's here and maybe we can see what's going on.
All right, Mr. Barber, are you working?
I'm not working currently, Your Honor. I'm just kind of helping mom out and friends out and stuff. And I'm trying to take and I'm waiting for my brother to take and get some work going on.
I believe we had, when you were failed to appear, Ms. Izett was here and she indicated that she believed that you were working as an over-the-road trucker.
Yeah, I'm not very successful quite yet on that.
Well, are you doing that?
I'm just helping a friend out, Your Honor. So
The question was, are you doing work as an over-the-road trucker?
I've been trying a little bit, and I'm just not successful yet. I'm trying to get my paperwork in order for that also.
What does not successful mean?
I just haven't been able to produce any kind of real money at it yet.
Who are you working for?
I was working with a friend of mine from high school, but he's been a trucker before. And now I'm kind of at odds. Huh?
I asked if you could be any more vague. Who are you working for?
His name's Harley. He's from Colorado. He's a friend of mine from high school in Colorado. He was a trucker before, and I'm just trying to gain pointers and insights on that there, and trying to get this stuff figured out.
So are you driving truck?
I tried to drive truck, but I don't have all my paperwork in order to drive. I'm still in the process of getting things going like that.
So what did you tell your probation and parole officer you were doing?
Driving truck, and I'm
So
trying
if you reported to him you're driving truck, why can't you tell me that you're driving truck?
I'm trying to make sure that I get everything in the licensing and everything straight.
So how many routes have you gone out and done?
Just a couple.
What time period?
Excuse me?
In what time period?
Couple of weeks ago. Just a couple weeks ago.
So have you been paid?
Not entirely.
What does that mean?
Well, I got money to do the job, but I didn't really get money for an actual payment yet. I got fuel money to do the job.
Are you trying to tell me that you're working for free?
I'm not successful. I haven't been a success yet, and I haven't made any real kind of success at it yet.
Why would this company pay you for your fuel and not pay you for your time driving?
It's still in the process of getting paid, trying to get paid for it, and I'm at odds with him also.
Mr. Barber, you're making it really hard to believe what you're telling me. Do you have some documentation from this company about the runs that you've made and about what is owed to you?
I can get some of that paperwork.
You're going to need to submit all of that documentation for all of the runs that you've made to the friend of the court so that they know what you're doing. Anytime that you're employed, whether you get paid for it immediately or not, you're required to turn that information into the friend of the court. Are you aware of that?
Okay. Yes, Your Honor, I am currently aware of that now.
So I expect within the next 3 days, well, if you're gonna run the paperwork to the friend of the court on your other matter, you can run the paperwork for your work to the friend of the court today as well. So let's get that in within 48 hours, either today or Monday. I need to see your paperwork on both your employment and your medical request into the friend of the court's office here in Otsego County. Do you understand that?
Yes, Your
If it's not here, I'm going to hold you in contempt of court. Do you understand that?
What is contempt of court?
That means I can send you to jail.
Okay.
Do you understand how serious this is now?
Yes, sir.
All right. The paperwork for your medical claim and the paperwork on your business with the trucking, all of it needs to be at the friend of the court's office either today or by Monday at close of business. Any questions about that?
No, sir, Your Honor. I do have a question of why I'm not being able to see my son. And I'm a great dad, and I'm trying to do the right thing. And the court is kind of disregarding my rights as a father on that matter.
Have you filed a motion about that?
I haven't got the transcripts back from the proceeding from the referee hearing yet, which proves many things.
Well, how is the court disregarding it if you haven't filed your motion yet?
I'm not really good with paperwork. And
The court can't do anything until you file a motion.
Say that again, please, Your Honor.
I said the court can't do anything until you file a motion and we have a hearing.
Right. I believe I attempted to file a few motions before, and that was the purpose of the referee. And at the referee hearing,
Well, that doesn't sound like you're being disregarded at this point if the referee had a hearing on it. I'm sorry, I'm not able to hear you now, Mr. Barber.
Huh?
On your phone ringing.
Yeah, my phone was ringing. It was a spam call.
All right, so if you're going to do something about your parenting time, you need to contact a friend of the court or you need to file a new motion. But there's nothing in front of me today about that. This is all on child support. Do you have any other questions, Mr.?
Yes, sir, Your Honor.
So, go ahead, sir.
What was the documents that the other party was supposed to produce?
The documents that you're supposed to produce are your medical records, that verification of medical form, and you're supposed to submit your new trucking employment documentation to the friend of the court today or Monday. That's the last chance you're going to have to do that. What else do you have a question about?
I was referring to the other party of Scarlett and what she was supposed to submit.
Ms. Kraus, is there any other documentation that's supposed to be submitted by the other party?
I'm not familiar with what he's talking about. I believe today's hearing was just for the show cause. I'm not aware of anything from the June 17th hearing. I don't know if he's referencing that in front of the referee.
Okay, Mr. Barber, I'm not the referee. I wasn't present at the referee hearing, so I don't know what you're talking about.
Yes, sir. Understood.
Yeah, if you have questions about it, that would be something to submit to the friend of the court's office so the referee can deal with it.
Okay, so
Anything
you're
else
not
today,
aware
sir?
so, and Your Honor, you were not aware of anything, documents that she was supposed to produce?
I just told you that I was not at the referee hearing, so I would not be aware of that.
Correct. Correct, Your Honor.
Do you have any other questions, Mr. Barber?
No, sir.
All right, that's all for today. Make sure you get your paperwork into the friend of the court by Monday.
Thank you, Your Honor.
Ms. Spillane, is this your matter?
Yes, sir, it is.
Have you had any contact from Mr. Stokes?
No, sir, I have not. However, he did have a third party come in yesterday and make an additional $1,200 payment that has not yet dispersed to his cases. I don't know how much will disperse to this case, as he does have 2 different cases with us. And it wasn't applied to a specific docket. It was just because it was a third party they had paid. And the disbursement unit will disperse it as they see fit. But that would mean he would exceed his minimum monthly obligation. More than likely, he's already just about there, maybe $25 short of his monthly obligation right now.
All right, so adjourn to monitor.
Yes, sir.
You recommend 30 or 60 days?
I think 60 days would be sufficient.
All right, let's do that. I'll see him next in 2 months. Cassandra Guinea and Greg Morgan, file 24-19670-DS.
Yes, Your Honor.
Mr. Morgan, thank you. Mr. Morgan is with us. Ms. Spillane, can you update me on this matter, please?
Yes, sir. This matter was adjourned from June 26th to monitor the defendant's payments. His monthly obligation is $134 and his balance is currently $1,304. Last payment received was for this month in the amount of $260. Prior to that, we received $250 back in January.
So this year he's made 2 payments?
Correct.
Covering about 4 months though, right?
Roughly, yes.
So he's 3 months behind this year. Mr. Morgan, how are you going to catch up?
Your Honor, I made that $260 payment last Friday. My plan is to make a payment like that every other Friday. I was also able to do my 6-hour Zoom defensive driving class out of Georgia. So that is freed up my license. I'm going to be paying my reinstatement fee this week. So I will have a driver's license again starting next week. And it's going to be able to allow me to be able to move a little bit freely and more work and just get this stuff caught up and back on track.
All right. Sounds like you got a plan. Let me bring you back in a month to monitor how you're doing, and then you can tell me how things go for that month. And as long as you're making your payments on time, I think we'll monitor you for a couple months and see how things go. So I'll see you in 30 days.
Yes, Your Honor.
All right. Anything else, Ms. Spillane?
No, sir.
All right. That's all for today, sir. Thank you.
All right. Thank you.
Mackenzie Miller and Kenneth Wood, file 24-19833-DS. Do see that Mr. Wood is, thank you, sir. Mr. Wood is present. Ms. Spillane,
Yes, Your
can you
Honor.
update me on this matter?
Yes, sir. This matter was adjourned from June 12th, and the defendant was instructed he had until June 19th to pay a sum of $703 to the specific docket. And if that had not been done, that he could potentially be committed to the jail for 7 days. He has made a payment for July. He did not do a payment in June. But he is also, I did chat with him briefly this morning, and there may be some potential changes to the case itself, but I'll let him share those details with you as I didn't really get a chance to fully get all the information before court.
All right, Mr. Wood, what seems to be going on?
I'm doing my best to make the payments, but I found out 3 weeks ago that my two daughters were taken from the mom and put in foster care, and I'm in the I got court Tuesday. I just got the text this morning for getting custody of my girls until she figures out her life. So right now, the kids are in foster care and they've been there for a month. I didn't find out until a week later after they were put in foster care.
All right, well, if the kids do get put into your custody, there's a portion of the law that says that the child support can be abated during the time period that the kids are in your care.
Yes, and
However,
I still plan on paying I'm still trying to pay I'm still going to pay what I'm paying now.
Yeah, because until that occurs, the child support still, I mean, it needs to be paid to whoever's taking care of the kids now. Once
Right.
you get the kids, I can see it being taken off at that point. But for now, the amount that you owe is still there.
Yes,
So
I
what
understand that, and I'm doing my best to make the payment. I should have another payment here, hopefully in the next couple of weeks. I'm doing the best I can. So
What happened to the June payment?
June I made in July, and I was going to make another payment, and that would be for the July payment.
All right. So, Ms. Spillane, did he pay the full 703 just late?
He actually played 708.
All right. So it sounds like he took care of that June obligation. He was just a little late in doing it.
Yes.
And here we are in the last day of July, and he hasn't paid July yet, but he's telling me he's going to. So, all right. I think I'm just going to monitor what he's doing at this point. We'll find out what happens with the kids and whether or not there's going to be an abatement. Mr. Wood, if the kids are given to you, you would need to contact the friend of the court's office and let them know that the children are now with you so that they can do an abatement of the child support for the time period that the kids are in your home. And then we'll let the court system that's dealing with the kids figure out where the kids go and how long they stay with which parent or in foster care. And then we'll make adjustments accordingly. Ms. Miller, are you here as well?
Yes, Your Honor.
Is there anything else that you need to add?
No, I mean, I don't know if there's been inconsistency on the payment, so I'm just hoping that they stay consistent.
Yeah, he's indicating he's trying to do that, so we'll count on him to do that. And you've heard me say that if he gets the kids, the payments would be abated while the kids are with him. So I'll just wait for that court that's dealing with the kids to tell me which way it's going to go.
Yes, Your Honor.
All right, Ms. Spillane, is there anything else that we need to do immediately?
I don't believe so.
All right, so let's monitor it for 30 days. We'll have everybody back then and see where we're at. Thank you.
Thank you.
Thank you.
All right, the next matter is Angela Gillespie and Andrew Wolf, file 25-20065-UN.
Yes, sir.
All right, I do see Mr. Wolf is present. Ms. Blaine, can you update me on this matter?
Yes, sir. This matter was adjourned from April 24th to monitor the defendant's payments. This is a South Carolina support order that we are enforcing. He has an ordered on arrears of $348, and his current balance is $12,422.43. Back in July, we received $600, but we did not receive any payments for June or May. April, we had received $350.
Mr. Wolf, what happened in May and June?
I had some health issues and that put me in the hospital. The payment I made in July last week would covered May and 90% of June. I will be making a $400 payment today, which should put me at a $50 hole. And then 2 weeks when I get paid again, I'll be making another $400 payment to catch me up.
All right. Sounds to me like you got a plan in place. Let's adjourn this for 30 days to monitor that process. As long as you do what you say you're going to do, there won't be any repercussions, Mr. Wolf. But you need to stay current. If you have health issues that put you in the hospital, please notify the friend of the court so that they know that you're not just blowing off the payments, that you've got some real medical issues. And then when you get out of the hospital, send them confirmation of your medical records. That'll help in the future for me to know that you're trying to do what you're supposed to do, but you were prevented from it. So I understand that life happens sometimes. So as long as you're in contact with the friend of the court, letting them know what's going on, we'll continue to work with you. All right, sir?
All right. Thank you, Your Honor.
All right. So I'll see you in about 30 days. Go ahead and make your payments and we should be good. Thank you very much.
All right. Thank you. Have a good day.
Dilla Cronin Mead and Brandon Mead, file 16-16255-DM. Set for a motion today. Council, I understand there may be a request to adjourn.
That is, Coordination Broad, Your Honor, on behalf of the defendant, Brandon Mead. We have circulated and submitted a stipulation just within an hour and a half ago. So we apologize we couldn't effectuate that earlier, but we are essentially asking the court to combine, plaintiff's counsel has filed a motion for choice of school on top of the already scheduled motion to essentially dismiss the current order. So we are asking to consolidate those and schedule for an evidentiary hearing in the future.
Mr. DeBreaker?
Yes, Your Honor. Thank you. Attorney Kyle DeBrucker on behalf of the plaintiff. Yes, that's my understanding as well, Your Honor. And I think we both agree that if the parties can't work out this choice of school placement issue at this point, then it's going to require some sort of evidentiary hearing.
All right. I fear we're on the same path as far as time frame goes that we were last year, but I guess we'll just make do with what we've got. I'll ask my staff to schedule it as quickly as possible. I assume that you're asking for a hearing in front of me.
If the court would consider having it in front of, did you say you? Did I hear correctly?
Yes.
Yes.
You want to do it in front of me or in front of the referee?
I think in front of you would expedite the process. I mean, if the court remembers this case, we are now in a conundrum due to the ordered school not accepting the child. So yes, the timing is now another issue. I don't know if there will be an objection to the referee's recommendation or not. I can't predict that. So if the court would accommodate, I would request it in front of you. However, if that delays the ability to get a hearing date, that's something to consider as well, I suppose.
Yeah, if I may, Your Honor, I would leave it to the court's discretion. I would note that I think the referee does have the power under the court rules to enter an order with immediate effect if he sees fit to do so. So regardless of an objection, I think there is a path one way or another, whatever gets us in front of the court at your preference.
Well, you're probably going to get in front of the referee faster than me. But if you're going to object to it, it's going to come to me anyway. So, I'm given the case history, I'm likely going to hear this eventually. But
August 14th at 1:30 for a half day.
August 14th at 1:30 for a half day. Can we make that work? That would be in front of me.
I'm looking right now. My only concern is I do have a subpoena out to the current school, and depending on what I review from that, I don't know how much, if I need to subpoena the previous school. Discovery needs to happen unless the court is going to limit discovery. Part of my request, which is basically getting into my motion, so I apologize, or my responsive motion, was to try to limit what the plaintiff can propose at the evidentiary hearing due to the previous order, and that was already litigated. So let me look at my schedule for the 14th and see if that's even a possibility. It is, I guess. Kyle, are you available that day?
Your Honor, at this point, I do have a Zoom FOC conference on another matter at 2 p.m. that afternoon. Best I could do is see if I can move that, but obviously I do not know sitting here right now.
And I would just again ask to reserve the right for additional discovery because that is about 2 weeks away and I'm not sure what I'm going to get from the subpoena I already have out.
All right. Sounds like I'm not going to be able to resolve it today. So here's what I'm going to say. Call the referees, call the friend of the court, see what the referee's schedule is like to get you in there. Call my scheduling clerk. She's with me in court today, right now, but she'll be back in the office this afternoon and find out from her when my schedule would allow. I assume you're asking for 3 hours, right?
Yes.
So half a day, basically, and take the first available date and do the best you can with it. Whether that means you get all the discovery you get, speed is better than you're going to do otherwise. So I'll leave it in your hands to do that. We'll adjourn today's hearing pending the scheduling of an evidentiary hearing, and we'll just make it work as best we can at that point, so we can make a decision as quickly as possible so the child can be at whatever school he's going to be at after this.
Thank you.
All right. Thank you both very much.
Thank you. Have a good day.
Kimberly McQueen and Gary Spicer, file 19-17938-DS. Who do we have present for that matter, please?
Kimberly McQueen present.
Thank you. We have Mr. Spicer with us.
I do not see him.
All right. I believe this is Ms. McQueen's what a motion for regarding parenting time.
Yes, Your Honor.
All right. You want to go ahead and tell me what it is that you want me to do and why?
Previously, when everything got settled, it was as parties agree, and we have not been agreeing. A little bit ago, a couple years ago, he took her to Wisconsin and did not bring her back in a month and wouldn't let me know when she was coming back, and I did not agree to that. So I would just like to have something set in paper to where if he does not bring her back when he's supposed to, I can actually exceed in getting her back. Otherwise, he has not been a part of her life. Yes, he did jail time for a little bit, and then we agreed for him to see her on Mondays. He did that for maybe 2-3 weeks. It's only a couple hours for Mondays, and then he just stopped showing up, and I haven't heard from him since. He recently paid a little bit to his child support back in June, I believe. Otherwise, he hasn't paid child support since years. So I don't know how you want to go about with everything.
Well, what specifically do you want the parenting time order to say?
Just Mondays from when, because school's going to be starting soon. She clearly doesn't really want to go there anymore. She hasn't seen him in so long. Otherwise, I mean, I guess my question is, if we set to Mondays from 4 p.m. to 6 p.m., if she doesn't want to go, do I have to force her to go?
How old is the child?
She is 8 years old, Your Honor.
It's difficult when a child doesn't want to do something. But as a parent, I think that you have lots of experience with the child not wanting to do something.
Yes, Your Honor.
So something as important as parenting time, typically the court does not allow the child to dictate what it's going to do. That's for the adults. When you're dealing with parenting time, that's why you and the dad are the ones that come to court, not the child.
Yes,
So
Your Honor.
if you're asking me, does the child need to go to regularly scheduled parenting time? The answer to that is yes.
Okay.
If there is some emergency, there's a mental health breakdown, or there's a acting out to the point of causing harm, or some other similar kind of circumstance where it's not just, Mom, I don't want to go, or I'm throwing a temper tantrum because I don't want to go. That's normal. I don't want to say it's good, but it's normal, or it's regularly occurs. So you have to do everything in your power in good faith to have the child go, to answer that
Yes, Your Honor.
question.
Thank you.
So what has parenting time been in the past? You went through it fairly quickly, but has there been any sort of regular occurring parenting time with dad?
Not really. It depends if he showed up or I was always it was never 50-50 transportation because his license and he couldn't find a ride and it was always just wish-wash. It was every other weekend for a little bit, but that was if, like I said, if he showed up. But recently we agreed to Mondays from 4 to about 6:30. Once you get out of school, he'd see you for a couple hours. I agreed to 50-50 transportation, but again, he stopped showing up. He did it for 2 or 3 Mondays, and I haven't seen him in probably about, I want to say it, a month and a half, 2 months. Haven't
All right.
heard from him.
Is there a current court order that says anything other than as the parties agree?
No, just as parties agree, Your Honor.
And you're considered that way, that he's going to keep the child like he did in the past?
Yes, Your Honor. Yes, Your Honor.
All right. So you're asking for parenting time for dad Mondays from 4 to 6 p.m. with 50-50 transportation? Or do you want
Yes, Your
something
Honor.
else than that?
That's fine by me. I appreciate it. Thank you.
All right. I will enter an order that says that. I'll need to get off the bench later today before I can fill that out and send it out to you. But I will enter an order that says parenting time for dad is Mondays. Do you want it to be every Monday? Is that what you're looking for?
I mean, I guess that's up to you. That's up to your preference. If you want to do every other Monday, I'm okay with that.
Does dad live in close proximity to where you're at?
He lives in Grayling. I'm in Gaylord, so about 20-30 minutes. And I would not, we could do, I'm nervous about, maybe we could do 50-50 transportation and meet halfway both times because I really don't care for him to be on, at my house.
Is there a specific place that you would like to meet at? A public place?
The Waters exit gas station, Marathon at the Hilltop. That would be about 50-50 for a good meeting spot.
The problem is with meeting halfway, sometimes if the other party doesn't show up, the party that's got the child is stuck waiting there for that to occur. If it's at the home, then you know the child's safe in the home. So is that what you want to do though? The Hilltop gas station exchange?
Yes, Your Honor. Now, if I don't hear from him and say I'm sitting there for over 10 minutes, do I just leave or is there a certain amount of a window time that I have to sit before I can, or how does that work?
Typically it's 15 minutes.
15 minutes. Thank you, Your Honor.
All right. I'll put all of that in a proposed order. Is there anything else that you'd like in the order?
That's about it. Thank you.
All right. I'll send that out to you as quickly as I can. Thank you.
Now, when does that start? That would be my only last question. Do I have to wait for the paperwork until I'm forced to have her go?
Well, today is July 31st. Do you want to start it on Monday, August 3rd, or you want to wait till Monday, August 10th?
Can we do the 10th, please?
Yep.
Now, is that going to be every Monday or every other Monday?
Every Monday.
Thank you.
All right. That's all for today. Thank you very much.
Thank you, Your Honor.
Carrie Livingston and William Livingston, file 15-16062-DM. Who do we have present for that matter, please?
Appearing for Carrie Livingston, the Cascade Legal Service by Wayne F. Crow Jr. Good morning, Your Honor.
Good morning. Do we have anybody on behalf of William Livingston? I do see Mr. Livingston is present. Mr. Livingston, can you unmute yourself, please? Mr. Livingston, can you hear the court? Mr. Livingston, can you hear the court?
Yes, I can.
All right, thank you, sir. This appears to be a motion to enter a qualified domestic relations order. Counsel, you want to update me on that?
Yes, Your Honor. So in May, we submitted a quadro on consent. Both parties have signed off on the quadro, and we have submitted it to the court. We were just asking for the court to sign off on it at this time.
Mr. Livingston, is that correct?
Yes, it is.
So there's no objections to this?
No.
All right, this will be submitted to the clerk's office. You guys can get copies by contacting the clerk's office probably on Monday before the file gets back there. Any questions or other
No,
concerns,
Judge. Thank
counsel?
you. Have a very nice weekend.
No.
Anything else, Mr. Livingston?
No, nothing from me. You have a great weekend.
All right, you too. This is the matter of Holly and Scott Telgetsky, file 25-20265-DM. Who do we have present for that matter?
Reagan Richards for Angel Anderson for plaintiff Holly Tolgetsky.
All right. I do see Mr. Telgetsky is present with us as well.
Yes.
So motion, no, that's not that.
This should be a bench warrant for failure to appear
Yep.
on 7/8.
Mr. Telgetsky, this is a bench warrant for your failure to appear on July the 8th at 10 a.m. What happened?
I had mistaked the time. I showed up 40 minutes late as they were walking out. That was my bad. I thought it was 11 o'clock.
Did you report to the Otsego County Jail for your
I
contempt?
did, yes. And I
So
paid
you've
the
done-
bond.
Done, so you did 3 days?
Yep.
All right. Ms. or counsel, do you have any additional information for the court?
No, Your Honor.
Well, sounds like a hard lesson, Mr. Telgetsky. All right, I'm going to withdraw the bench warrant. You've done your time on the contempt of court charge. It looks like there's another hearing set in August on another motion, so I'll let you guys deal with that then.
Yep.
That'll be all for today, Mr. Telgetsky. We'll withdraw the bench warrant.
Thank you.
Ms. Stinson, is there anything else I need to do? I mean, I know the form needs to be provided or signed for that, but is there anything else that you need from me on that Telgetsky case?
I don't think so.
All right, I just want to make sure I didn't miss anything. Thank you.
I'll let you know.
Thank you. All right, this is the Warren matter, Madeline and Tyler, file 25-20287-DM.
Good morning,
Here's
Randall
the counsel.
Blumberg on behalf of Miss Warren. She's in our waiting room. I have to get her. I got a bunch of people waiting to get on, so give me a moment,
All right.
please.
Thank you.
Well, he's doing that, Your Honor. Zach Backlund on behalf of the defendant in this matter, Tyler Warren, who is appearing with us by Zoom as well.
I do see Mr. Warren is with us. All right, we'll wait for Mr. Blumberg to get ready and we'll proceed.
We're all set. She's here.
All right. Where are we at on this matter, counsel?
Judge, nothing has been resolved on a permanent basis. We have a temporary parenting time schedule that's been in place for a while now. There are certainly property issues that need to be resolved. I suspect we could go to mediation to at least address some of the issues that you may have to ultimately decide.
I agree with that, Your Honor. I believe that these parties could be fairly successful in mediation. I know there were a couple items to be resolved last time we were here, one of them being the child support. We received a new recommendation this month, and I think the expiration date expired yesterday, actually. We didn't file an objection. I don't believe Mr. Blumberg's office did either. So the custody and parenting time issues, along with the child support, at least on a temporary basis, are resolved. And then we're just debts and equities at this point, I believe.
Judge, there is a temporary order that's not terribly specific in regard to the payment, maintaining the status quo. There are bills that are monthly, reoccurring bills. Mr. Warren's been making contributions, although they seem to be in varying amounts and from month to month on different items, but that needs to be, I guess, solidified in some fashion.
Well, let's deal with that at mediation first, and then if you can't get that done, I can consider that near the end of the case.
Okay.
So let me send you to mediation. Community mediation sufficient, or do you guys want to do something else?
I would hope that we could get an attorney mediator involved rather than community mediation. That would be my expectation.
I don't object to community mediation, but Mr. Blumberg and I have utilized like Jerry Sheffalo as a mediator in the past. I know he does good work, so I'm certainly okay if we need an attorney mediator on this one.
And I think we could
no
stipulate
objection to
on
that.
We could stipulate on Mr. Sheffalo.
I would be okay with that. Yeah.
All right, let's do that. I'll let the parties set the dates along with Mr. Sheffalo's schedule. Can we get that done in the next 45 days?
Depending on Mr. Sheffalo's schedule, I think we could do that.
All right, well, let me set another status conference then in 60 days, and that should give sufficient time for everybody to get things done. Is there anything else that needs to be put in a pretrial order?
I don't think so. Judge, maybe you can clarify. We had filed a motion asking Mr. Warren is going to be on some type of military leave for an appreciable period of time. We had filed a motion to ask the court to allow my client to have the children during that period. I don't know if that's up for today or not, or is that on the court's docket?
I'm looking at the file right now. I think that's before referee legal on September the 16th at 10:15.
Okay, thank you for clarifying that.
Yep. All right, so I'll simply do a short pretrial order indicating that property issues still are outstanding. I'll send the matter to mediation in front of Attorney Sheffalo, and I'll set a status conference in 60 days.
Great, thank you.
Thank you, Your Honor.
Thank you both. All right, thank you. That's all for today.
Thanks.
Next matter is Darren and Catherine Green, or maybe Catherine McMasters now, case 22-19106-DM. I can have the appearances of counsel, please.
Again, good morning, Your Honor. Elliot Blumberg on behalf of Ms. McMasters.
All right, do you see Mr. Green is with us as well? Mr. Green, do you have an attorney representing you or not?
I do not, Your Honor.
All right. Mr. Blumberg, is this your objection to the child support?
It is, Judge. And the objection arises from Ms. McMasters' attempt to participate in the referee proceeding on the issue of child support. She was waiting to get in and to be admitted, and for reasons that, again, I wasn't present for that, but she was not able to get in, and so her objection, or at least her position as it related to her income, was not presented before referee legal. The friend of the court has imputed an amount of income for someone in her legal capacity or in her professional capacity, and it just simply isn't what she's making. She's a relatively new limited license counselor or therapist, temporary actually. And so we do now have her tax returns that we would like to be able to present to the friend of the court to do a revised child support obligation recommendation.
Ms. Kraus, is this your matter?
This is.
All right. Mr. Blumberg, is it correct that the referee hearing was back in April?
I think that's right, yes.
Why did it take so long to, I guess your request was in May, so it's just been scheduling it in front of me that took so long. So all right, I answered that question. All right. Ms. Kraus, is there a threshold that needs to be met for a change? Is my memory correct with that?
This was a new recommendation for that. The information that we used, because nothing was provided, was based on the Michigan labor and market information for that type of employment, because we received no information from her for the support recommendation.
So if she submitted appropriate tax documentation, you'd be able to make a determination of what it should be or what it could be under that. And then the referee could determine whether or not it should be changed or not. And then everybody can make their objections later if they wish to.
If the court requests that we do that, because it was originally objected to, but then she didn't appear for the objection hearing.
And again, just to be clear, Judge, with all due respect, Ms. Kraus, she was not admitted into the courtroom. And again, I wasn't there, but I know how that can be if you don't identify yourself or something along those lines. She was physically attempting to appear by Zoom.
Her message. I have a note in our system that questions if this was even filed in a timely manner. The date was given to Wendy at Bloomberg's office on May 19th. That's when they called for the original motion for a date. So FOC, I believe it was Edward that had questioned if this was even filed timely.
I think it was. Let me just.
She was arrived. So.
Yep. So April 29th. So Wednesday, May 18th. Okay, so we got 1, 2, yeah. It's within 21 days.
Okay.
So all right. I am going to allow Ms. McMasters to submit the tax documentation that she has to the friend of the court for a calculation of that. I think it's best to use actual numbers as opposed to imputed numbers at any opportunity that we can. And it does appear that the motion on the objection to the child support recommendation was made within 21 days of the actual hearing date. So it was within the appropriate time periods. So I think it is appropriate. And then I'm going to direct the friend of the court to send out a new recommendation based on the tax numbers. Mr. Blumberg, what specifically is she going to be able to submit as far as amount of tax records? Is it just for this 2025 year?
Yes, those are the most recent ones. Yeah.
All right. Ms. Kraus, is there any other documentation that you would ask for that would update that through a part of the year for 2026? Is there anything else that you would look for?
Given that I'm not sure what information, if she's filing as if it's a 1099, her own business, I'm not sure what documentation that they will be providing. So I would just request that if additional information is needed, that it would be submitted timely for our office to review that documentation.
All right. Mr. Blumberg, was she? Thank you. Thank you very much. I appreciate that. Was she fully employed in the current position that she's in throughout 2025, or was it only part year information?
Fully employed.
All right. Is she an owner of her own business, or is she employed through some other agency or other?
Yeah, she's a contract employee.
All right. Does she get a regular paycheck from that contract, or how does that work?
Yeah, she gets a paper paycheck every pay period.
All right. I would ask that she submit from January through June, a half year of 2026, in addition to the tax records for 2025, so that we get the most up-to-date information for that. And then I'll ask the Ms. Kraus to do the full recommendation and send that out with a 21-day time period for any objections to that, as they normally would. Is there anything else that you'd ask for, Mr. Blumberg?
No, Judge, I appreciate that. That's a reasonable request of the court. We'll do that.
All right, Mr. Green, any questions or any comments that you have?
Yeah, I object to that, Your Honor. You said she was within her 21 days. This is her fifth option or fifth I guess, option for her to be able to submit her information. She should have updated the court when she changed positions. That's, from what I understand, the rules of the court. And then on January, it was beginning of January, they sent out a request for us to provide information. She neglected to provide at that time. They sent out a second request, which was 21 days later, and she neglected to submit information, in my opinion, a third time. So then once they made the recommendation, she decided she didn't like the recommendation, and then she made an objection, which she failed to appear. So I don't, and my paperwork says that defendant failed to appear and has therefore.
What began as a simple landscaping project between neighbors quickly turned into a courtroom battle over property damage, responsibility, and thousands of dollars in repairs. One family claimed their neighbors changed the grading of their backyard, adding sand, shale, and landscaping material that eventually washed into their French drain system during heavy Texas rainstorms. They say they warned their neighbors months before the damage became serious, but no action was taken. Professional landscapers later inspected the drains and concluded they had become clogged, recommending costly repairs. The defendants told a very different story. They argued the real problem wasn't their landscaping. It was the natural slope of the neighborhood, where runoff from multiple uphill properties had always carried mud and sediment downhill. They insisted they installed barriers, improved drainage, and never intentionally caused damage. As both sides presented photos, expert opinions, and months of text messages, one question remained. Was the clogged drainage system caused by a neighbor's landscaping, or by years of unavoidable water runoff? Unable to reach an immediate verdict, the judge postponed the decision, promising to carefully review the evidence before issuing a final ruling, leaving both neighbors waiting to learn whether this costly dispute would finally come to an end.